Right. Question number 1. Kamal is the sole proprietor of manufacturing and selling different types of school exercise books. Now he is seeking the possibility of incorporating the company under the Companies Act to expand his business. Identify different types of companies that can be incorporated under the Companies Act. Right? So, actually, 4 marks given. Therefore, actually, we can analyze the expand the types of companies and register. Right? Basically, we can incorporate 3 types of companies: limited, unlimited, company limited by Galle. Right? Then limited companies we can further classify as private companies and public companies. Public companies can be classified as listed and unlisted. So these are the types of companies that can be incorporated under the Companies Act. Right? What about the offshore companies and overseas companies? Offshore company and overseas company, apart from these types, what about them? Now, when we consider offshore company, right? Offshore company is a company which is registered as an offshore company under the Companies Act. It may be incorporated in Sri Lanka or abroad. Right? So if it is in Sri Lanka, then private company, as a private company, public company, they can be incorporated. Actually, it is not a different type of company. Right? So it may be incorporated here or abroad. So if it is abroad, actually we can't consider that under the company sector. Right? When we consider the overseas companies, these are types of companies, right? Overseas companies, they are incorporated abroad. Not in Sri Lanka. Therefore, we cannot incorporate the company as overseas company, right? This is incorporated abroad and doing their business activities in Sri Lanka. The type of companies are known as overseas companies. Basically, we can identify these, right? Listed, unlisted, right? Private, right? Then thereafter, unlimited companies, company limited by government. So together there are 5 types of. Basically, we can identify 3 types. Right? This limited, unlimited, company limited by government. So limited companies we can further classify as private, public. Public companies we can further classify as listed, unlisted. We can start from here: listed, unlisted, private, right? Unlimited company limited. So if we consider listed company, they are public limited companies. So there are 5 types we can look at. Then thereafter, explain the procedure for the incorporation of a limited liability company under the Companies Act. So basically, in order to incorporate a company under the Companies Act, we have to submit 5 documents to the register. Right? First step is we have to submit 5 documents. Right? 16A, Form 1, then Articles of Association, Form 18, and Form 19. Right? This is the Form 16A. This is the name approval form, right? And application form. It will be signed by the initial shareholders with the declaration. That is, to the best of their knowledge, the name of the company is not identical or similar to an existing company. And articles of association here, actually, we can have three options. We can adapt the model set of articles set out in the first schedule. First schedule to company set. And another one is the company can prepare its own set of articles. Right? Own set of articles. Another one is we can alter the model set of articles and adapt it. Like alter model set of articles. Yeah. These are the concepts of the initial directors, like as the directors of the company. For 19 is the concept of the initial secretary, like as the secretary of the company. Application is the application form one. Right? So after submitting these documents, then what happens? Certificate of incorporation is issued. That's the main thing. Particulars of the company intercompany register, signed during number, and certificate of incorporation is issued to the company. Then after incorporation, within 30 working days, public notice to be given. That is the requirement. Public notice, right? To be given by publishing an advertisement in a newspaper, mentioning their name of the company and company number and address of the registered office. Right? In three languages, single language and English. So by that way, you have to give the public notice. Then proof of the public notice to be given to the registered companies within 60 working days after the publication. Right? So that is the procedure of incorporation. So, yes, after publication of the public notice within 60 working days, proof copy of the public notice to be given submit to the register of companies. Right? So this is after incorporation, after certificate issued, the company already incorporated. After incorporation, within 30 working days, notice to be published. After the publication, within 60 working days, proof that is the copy of the payment is submitted to the register. Right? So these are the steps we follow. Right? You will be incorporated. Right? After the company is incorporated, it is treated as a person separate from those who create it only when it is. Thus, identifying company as a separate person is known as way of incorporation. A separate legal person. Explain the exceptions to the above rule of way of incorporation. Right? So actually, way of incorporation is identifying the company as a separate person. Like that concept for the activities of the company itself is responsible. Right? There is always way of incorporation or legal personality. But because of some reasons, we can lift the veil of incorporation. Now, what happened actually, because of the veil, third party cannot see beyond the veil. Right? Therefore, the third party can see only the company. Therefore, for the activities of the company is responsible. Right? Third party can file an action only against the company, right? Not against the directors, employees, who promote or whatever. Officers are not responsible for the activities of the company. But because of some reasons, we can lift the veil, remove the veil. So, lifting of veil of incorporation is making directors, employees, or the promoters of the company responsible for the activities of the company. Right? Uh, so lifting of weight, or we can identify them as exceptions to the veil of incorporation. Right? There is a lifting of veil of incorporation. So here actually we can identify two methods, right? Two methods we can lift the veil of incorporation. One is on the company side, right? The case law principles. According to the case laws, we can lift the veil of incorporation. Here, Olympia, when we consider the company side, right? The first one is that is with regard to the name of the company. If the name of the company is not properly mentioned on a document which creates a liability, then if the company refuses to admit the liability, then person who signed the document is person responsible. This is section 12 of the company side. Then the second one means there is we are the director of the company. Right? It is actually under the duties of the director, we have discussed this, right? Director of the company came to know that the company unable to pay its debts. Right? Then immediately, right? Immediately he must call what? Which type of meeting? He must call a meeting, right? Meeting of who? Two types of meetings, directors meeting and shareholders meeting. Okay, and when we consider the meetings, meeting में होगा कितने किया है? There are two types of meetings: directors meeting and shareholders meeting. So shareholders meeting we divide into two, and that's AGM and EGM. And so under duty of solvency, sorry. Insolvency, right? Under duty, when we discuss the duties of the directors, uh, the company unable to pay its debts in its ordinary course of business, that is insolvent, right? So that is something that we have discussed as a heading, duty in insolvency. What is the duty cast on the director? He must call a meeting. Only call a meeting. Which type of meeting? There are two types of meetings: directors meeting or shareholders meeting. Yes. If he fails to call the meeting, then as a result of company continuing its business, and liquidated, then the person is responsible for the creditors. Whether there is responsibility of the person is responsible for the creditors. Which type of meeting to be called? Directors meeting or shareholders meeting? Meeting to be called. Which type of? Otherwise, they are the directors meeting. Right? Because the reason is he must call a directors meeting in order to decide whether the company should apply to court for winding or whether continue the business of the company. We don't decide. So we can't settle it with the shareholders. Right? That decision to be taken by the directors. Whether the application to be made to court to wind up or further carry out the business of the company. If he fails to do so, right, if he did not call the meeting, then he is personally responsible for the creditors. Only duty is calling court meeting. Right? That is the duty. Call the meeting. Once he came to know that the company is struggled with the day-to-day transaction unable to pay its debts, immediately he must call court. That is the duty. The duty is called the meeting. That is directors meeting. Right? Directors meeting. Over what program? Right? Directors meeting. Right. Then there is another exception for the veil of incorporation. Then there is another exception we have discussed, group accounts. Mother company has to prepare mother company. mother company and subsidiaries. Is 2, is 3 likewise has any subsidiaries, but maybe as a concept of legal personality concept under actually mother company is a one company. Subsidiary one is a subsidiary, but it's another company. S2 is another company. S3 is another company. Separate persons. Actually, altogether we can identify there are 4 persons in this example. 4 persons. Mother company is a one person, legal person. Subsidiary one is another person, another legal person. But in order to prepare the group accounts for the entire group, right, we link the way of incorporation of the subsidiaries. The treat them as an economical units, right? Economic units. Economic unit. Right? Only for the accounting purpose, right? And give the way of incorporation and treat them as a single unit and prepare the group accounts for the entire group. There is another way that we can give the way of incorporation, right, in order to prepare the group accounts for the entire group, right? Another occasion under the companies. Then thereafter, under case law principles, we can link the way of incorporation. The first one is very important one. That is, the person who has incorporated a company in order to do an illegal activity. Illegal activity. The person has used this concept, separate legal personality concept, in order to do an illegal activity. They actually form can link the way of incorporation. So actually, this type of companies are known as powered companies or share. Powered. Powered रूपरेखी ऐसे regular निर्देशन कराना and in order to an illegal activity. That type of companies are known as right powered companies. It actually more can link the way of incorporation. The second one is because of the national emergency, right? Because of the national emergency, court can link the court can link the way of incorporation. Right? So we want to identify who is the actual real owners of the company. One case we have mentioned that is more against the England and Germany, right? For the of incorporation in order to identify who are the owners of the company. Transaction with the enemies are political according to the terms of war. If right, this transaction is not valid, that person need not to pay money to the enemies, right? So likewise, we have discussed 2 cases under this, right? When we consider the case law principle, first thing is nobody can do any illegal activity by using this concept. Separate legal person. First, we have to consider whether it is legal or illegal. And in order to evade the law or the legal obligation, nobody can use this concept. Separate legal person. So that is the first part. The second one is there is because of the national emergency, court can leave the way. There are 2 cases we have mentioned. Right? So actually, by these ways, we can leave the way of incorporation according to the Companies Act and case law principles. ඊට පස්සේ ලියන්න දෙන්න ඕනද නේද? ඒක ඕනේ නේද? ඒක ගන්න. අපි කල් ලියමු ටිකක් නේද? ඒක ලියන පොතේ ඕනේ. මේක නම් නිකන් ෆැක්ට්ස් ටිකක් තියෙන්නේ. ඉතින් ඒක තමයි. Way of incorporation, lifting of way of incorporation के facts के लिए तो हम दान चाहिए। फर्स्ट टर्म में 3 और फर्स्ट case study solution. ABC Limited is a question number 2. Limited ABC Limited is a company public company duly incorporated under the Companies Act. According to the Articles of Association, its object is in line with selling computers. However, last month, ABC Limited engaged into a contract to sell smartphones. Further, the articles of ABC Limited provided that every shareholder shall have preemptive right over the shares of other shareholders. However, Mr. Pereira, a shareholder, sold his shares last week by violating the other shareholders' preemptive right. Right? Explain the ultra-virus rule, because introducing Ricky versus Ashbury Railway Company Limited case by considering the above contract of ABC Limited to sell smartphones. So first, we have to explain the ultra-virus rule by considering the contract, or maybe consider the question. It says the main objective of the company is selling computers, right? It, they engage into contract to sell smartphones, right? So then, by considering that transaction, we have to explain the ultra-virus rule. It's simple, right? How we can explain the ultra-virus rule? Actually, we need not to consider about this case though. Actually, this recognizing ultra-virus rule, recognizing this case, right? Actually, what is the ultra-virus rule? Now, ultra-virus rule is now company. This is regarding the Articles of Association. In the Articles of Association, company may set out its objects. Right? So accordingly, in this company, its object is selling computers. Right? Then this company cannot engage into any other transaction other than this selling computers. Right? So if they are engaged into contract to sell smartphones, then that type of contracts are known as ultra-virus transaction. Ultra-virus transaction. Ultra-virus means beyond the objects of the company, right? If we consider the object clause, that is the scope of the company. By object clause, it prepared the scope of the company. So within that scope, company can engage into any transaction, but cannot, right, go beyond the scope. So here the object is selling computers. The company's transaction must be restricted only to selling computers. Right? They cannot sell smartphones. That is beyond the objects of the company. So if the transaction is beyond the objects, then that transaction is known as ultra-virus. Ultra-virus, right? Transaction. Right? Beyond the object, ultra-virus. Within the objects, intra-virus. Ultra-virus and intra-virus. Right? Galle अतिक्रमण करना, Galle तुरंत इग्नोर किया जाए. Then according to the common law, that is this Vicky versus Ashburn Railway Company Limited, it says if the transaction is ultra-virus transaction, it is void contract. It will be treated as a void contract. Therefore, nobody can see any variation, right, on that contract. That is the decision given in this case, right? How do you hear this? The company, they set out, its objects in the Articles of Association. But the year or short form it is so but I the company may set out its objects in the articles of association. Next line we can say, if the objects are mentioned in the articles, then the company cannot engage into cannot engage into the company cannot engage into transactions 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 beyond its objects beyond its objects. Next line we can say, if the transaction is beyond the objects, if the transaction is beyond the objects, of the company, such transactions are known as ultra-virus transactions, UV transactions, ultra-virus transactions. Ultra-virus transactions. Right. Then next time we can say, according to the case laws. According to case laws, ultra-virus transactions are void contracts. Here actually we need not to mention about the provisions contained in the Companies Act. Right? When we consider the provisions contained in the Companies Act, section 23, it says, right? Actually, section 23, section 70, subsection 1 and subsection 2 of the Companies Act. It says, subsection 1 says, the company and the management of the company must engage in contract which are identified under the objective, right? And section 72 says, right, even though the transaction is ultra-virus transaction, right, it is valid and enforceable. Valid and enforceable. Right? So, two sections recognize that status of the ultra-virus transaction. First, it says ultra-virus, right? Company and the management of the company shall restrict its activities according to the objectives, right? Section 17 says. And further, section 72 says all the transactions are valid and enforceable. All the transactions is ultra-virus or intra-virus. all the transactions are, then you can enforce it. But then further analyze, however, valid and enforceable, even though it is an ultra-virus transaction, it is valid and enforceable. But there are two effects. One is before engaging into ultra-virus transaction, any shareholder or director can bring an action in order to prevent the company from engaging into that ultra-virus transaction. Right? Injunction. Right? By seeking an injunction, any shareholder can bring an action against the ultra-virus transaction. That is before. After actually nothing to prevent, already engaged in the ultra-virus transaction. Then what happens? Out of this ultra-virus transaction, if the company suffers any loss, then what happens? Directors are personally responsible to compensate the company. So the responsibility is given to who? Directors. They are responsible to pay damages to the company. Right? If the company suffers any loss by this ultra-virus transaction. So by that way, like we can identify the legality of the ultra-virus transactions on the company side. Right? ඒක ඉවත් කරලා නැහැ. ගොඩක් අයගේ තියෙන පොඩි මිස්කන්සෙප්ෂන් එකක් ඒක ඉවත් කරලා තියෙනවා. ultra-virus rule එක ඉවත් කරලා නැහැ. ඉවත් කළා නම් shareholder cannot bring an action in order to prevent the company. Right? Injunction. We cannot, shareholders cannot bring an action against the company to prevent the company from engaging into ultra-virus transaction. Therefore, again, it is not removed. That concept is not removed by the provisions. It is admitted, indirectly admitted. Only thing is, right, before engaging into that, they can prevent. After engaging into the ultra-virus transaction, then what happens? If the company suffers loss, the directors are personally responsible. Right? Actually, that is the effect of the ultra-virus transaction. Right? So, there is the second question which says, identify the effects of ultra-virus transaction on the company side. Right? We have already before, highlighted before engaging into ultra-virus transaction. Before engaging into ultra-virus transaction. The shareholder can bring an action against the company to prevent the company from engaging into ultra-virus transaction. Right? So in brackets you can say injunction. Right? Injunction or file an action by seeking an injunction. Right? So there is the before engaging into ultra-virus transaction. After, right? Then next time we can say after engaging into ultra-virus transaction. After engaging into ultra-virus transactions, if the company suffers any loss, then the directors the directors of the company responsible to pay damages to the company. Responsible to pay damages to the company. Right. So that is the effect of the ultra-vires transfer. Then advise other shareholders for violating their preemptive right by Mr. Pereira. Now here, actually this is in the articles of association, it says every shareholder shall have preemptive right over the shares of other shareholders. Right? However, this one person, Mr. Pereira, has violated that provision and sold his shares to Mr. Pereira is here. Mr. Pereira, shareholder sold his shares last week by violating the other shareholders' preemptive right. Now, what is the question? Advice other shareholders. What is the advice can be given? Now, if we consider the
first of all, this Mr. Pereira can't be able to sell the shares without his signature of the other shareholders.
we can say, but only thing is right is equal to others. Because
no, without informing that,
yes, we can pass it. But only thing is the.
But how they do the alteration by forms?
Which one?
Form director form would be altered.
You don't transfer it.
Yep.
No, yes, we can transfer. Right?
Without the consent of
Yes, no, he need not to get the consent. As a normal transfer, he can sign it. Transfer this, he can sell it. Sell it to another
person.
person.
The point of that, the turning point is the ownership will be done by doing the form number 18 or what?
Form 18 is the consent of the directors. Director, this shareholder, all the shareholders may be not the directors of the company. They are the owners of the company. Right? These not to be the directors. If any changes made to the board of directors, to be informed to the register of companies. Right? By way of Form 20, they have to inform it to the register of companies. Right? Within 20 working days, by way of Form 20, we have to inform. Right? This transfer in the shares, right, owned by the shareholder or Mr. Pereira to another person. But only thing is, according to the article, it says the priority to be given to the existing shareholders. That is known as preemptive right. So by violating that, he has transferred. What is the relief available to the other shareholders? Advise other shareholders for violating preemptive right. Right? Actually, what is that? Can they file an action against Mr. Pereira? They can. Reason? Yes, it is mentioned here. It is not informed. Without informing, he sold. By on which right they can file an action against Mr. Pereira?
Which of them?
Breach of contract. Yes, breach of contract. Right? It means now, when we consider the articles of association, actually we have to consider two things. One is ultra-virus transaction. Right? The second issue is by the provisions contained in the articles, right? Binding contract may be formed between contract will be formed between company and another company and single shareholder. Between company and single shareholder. And the second contract will be formed between single shareholder and the other shareholders of the company. Right? But only thing is, binding contracts formed like this only by the provisions with regard to his capacity as a shareholder. Right? Only by the provisions with regard to his capacity as a shareholder, binding contract formed. Here that Vivastha एक रखे रहती है और एक होने देवा लैपटॉप तरफ लाइक हफ्ते भर के क्या any provision not violating the company's side. We set up any provision not violating the company's side. वो क्या दायरा पुलाट हो तो अवसर है හැබැයි ඔය හැම එකෙම ගිවිසුමක් හැදෙන්නේ නැහැ. ගිවිසුම හැදෙන්නේ කොටස් කීපයක් විදිහට. හරි. කොටස් කීපයක් විදිහට වෙබ්පේජ් යාට ලැබෙනවා කියලා මේ ප්‍රොවිෂන් එකේ කියනවා නම් අන්නේ ප්‍රොවිෂන් එකේ තමයි ගිවිසුමක් හැදෙන්නේ. ඒක තමයි වැදගත් වෙන්නේ. දැන් මෙතන ඉඳන් කියනවා මේකේ ඉඳන් කියනවා articles provided that every shareholder shall have a preemptive right over the shares of other shareholders. So this provision is related to his capacity as a shareholder. And as a shareholder, this right is given to this person, not as a director, not as the accountant or promoter of the company. Right? This right is given to this particular person as a shareholder. Therefore, by this provision, binding contract formed between single shareholder and the other shareholders of the company. So, if Mr. Pereira, a shareholder, has violated this provision and sold the shares to outside party without giving the choice to purchase the shares to these other existing shareholders, then existing shareholders can bring an action against Mr. Pereira, the shareholder, right, on the basis of breach of contract. Understood? Right? There will be one, every director is entitled to receive 100,000 rupees salary per month. Right? By this provision, no contract form. Because it is related to his capacity as a director. Yeah, objection to the claim of Matama, एक याद दिया. एक किसी में कहते हैं एक मतलब क्या है? अरे तमदे provision में क्या related इन्होंने shareholder के लिए ये तो आप आइडिया दे सकते हो ना व्यवस्था है. एक gives no तो एक वायरस तो उसका होगा नहीं. other shareholder or the company or whatever this part can action against the person who has violated that provision in order to recover damages. Allowing them to other people and related to his capacity as एक mention करा एक तमाम एक authority कहते हैं not the ठीक है अध्यक्ष करने के लिए रुपया लाख मास काम देना के लिए ना एक ही एक्टर गिविस मार्क में गिविस मार्क निर्माण है कि ऐसे का वायलेट करा अध्यक्ष को रहेगा करो not the bad तो व्यवस्था में दी तो ऐसा अरे मकाबले की बात करता है वो लाख को देखो ये ना कि इल्ला no contract formed by that person because it is related to his capacity as a director, not as a shareholder. Right? How do you believe? Right? By the provisions, contain in the articles of association. Articles of association. Two contracts formed. Between a shareholder and the other shareholders of the company. The shareholder and the other shareholders of the company. Or a shareholder and the company. Shareholder and the company. So one contract is formed between shareholder and the other shareholder. Second contract is formed between shareholder and the company. Right. You should take up that. Right. In this slide we can say, however, these binding contracts formed only by the provisions, which are related to his capacity as a shareholder. His capacity as a shareholder. Related to his capacity as a shareholder. Right? In this time you can say, this article says, right? This article says every shareholder shall have a preemptive right. Over the shares of other shareholders. Over the other shareholders. It's like, by this provision, the binding contract formed between the company, sorry, here, formed between the shareholder, Mr. Pereira, and other shareholders of the company. Right? We can say other shareholders are entitled to file an action for damages. On the ground of, on the basis of, breach of contract. On the basis of breach of contract. Breach. Breach of contract.
If they not paid a particular 100,000 as a director, he don't have any payment.
As a right, he cannot ask that.
Reason?
Reason is no binding contract for.
But it is mentioned the same in article as presently.
It is mentioned in the article.
Even though the company is not responsible for that.
No responsibility.
So what is the rationale behind it?
Sorry?
What is the rationale behind it?
No contract. Only by the provisions related to his capacity as a shareholder by the contract. Understand? Fine. Automatically by the contract. But suppose I have mentioned another case, right? According to the article says every director is entitled to receive 100,000 rupees. By that provision, no contract formed between company and the director. But what happened in that case? Director relied on this provision and he became a director of the company. Then according to his appointment letter, that is the agreement already made between company and the director, in his appointment letter, salary payable is not mentioned. Then what happened now? If the salary payable, how much to be paid, that is, if it is not mentioned in the appointment letter, right? Then what happened? The company has attempted to pay him lesser amount than the 100,000 rupees. This is what happened. This director make an application to the court, right? In order to get the 100,000 rupees. And here actually court held by the provisions contained in the articles, no contract form. But that provision contained in the articles may be treated as an implied term of the appointment letter. Therefore, implied term. Now, when we consider the terms of a contract, there are two types of terms. Contracting terms, there are two types of terms. One is express terms. Express means in writing or orally party-subject terms are known as express terms. Another type is implied terms. We can imply some terms into the contract. So here court says we can imply this provision contained in the articles to the appointment letter. So this is the contract already made between the company and the director. Right? So this is the implied term. Therefore, the company cannot pay him lesser. Understood? But here, if it is related to his capacity as a shareholder, by that provision, contract form. By the contract form. Right? By the contract form. But if it is related to his capacity as a director, no contract form by that provision contained in the article. But it may be treated as an implied term of another contract. Between company and the director. ඒ විදිහට තමයි යන්නේ. ඒකේ බෙද් එක. විවිසුමක් හටගන්නේ බෑ ඒක තියෙන්නේ. හැබැයි ඒක කොටස් විදියට යන දීපු අයිතියක් නම් ඒක විවිසුමක් නිර්මාණය. ඒ ප්‍රොවිෂන් එක. වෙන විවිසුම මොකක්ද? ඕනේ. ඒ ඔබට ඕනේ ඒකේම නිර්මාණය වෙන විවිසුම. ඒක තමයි වයලේට් කරන්න බෑ කොටස් විදියට කරනවා. as a shareholder he can take an action. Breach of contract. හැබැයි අනිත් අයගේ අධ්‍යක්ෂකවරු කොටස් විදියෝ නොවන වෙනත් අයකට දීලා තියෙන අයිතිවාසිකම් සඳහන් වෙලා තිබුණත් ව්‍යවස්ථාවලියේ no contract. කොපෙටිගේ no contract. හැබැයි ඒ ප්‍රොවිෂන් එක වෙන කිසිමක හරි කියන්නේ ව්‍යංග කර්මක් විදිහට සලකන්න පුළුවන්. වෙන කිසිමක ඇතුළත් වෙලා තියෙන ව්‍යංග කර්මක් විදිහට සලකන්න පුළුවන්. ඒ නගරිනුවේ මෙයා අධ්‍යක්ෂකවරයෙක් වුණා. අපොයින්ට්මන්ට් ලෙටර් එකේ තිබෙන්නේ කීයක් දෙවන්න ඕනද? ඒක අධිකාරිය නම් කියනවා අරකේ විවිසුමක් හැදෙන්නේ නැති එක ඇත්ත. නම් we can imply this terms into the contract already made between company and individual. ඒක ව්‍යාප්ත වටහාගන්න ප්‍රොබ්ලම් පිළිබඳව කතා කරනවා කියලා හිතන්නේ. හරි. මේක එකේ බලපෑමක් වෙන්න පුළුවන්. ඒකයි කියන්නේ වෙනත් කිසිමක වටහාගන්න ඉන්නවා. කිසිමක් හැදෙන්න ඕනේ. අපේදී හැදෙන්න ඕනේ ඒ ප්‍රොෆෙෂන් එකේම කිසිමක් නිර්මාණය. මේක ඒක අයිතියක් විදිහට ඉන්ටර්නැෂනල් එක වයලට් කරන්න. හරි. ඒක කොටස් විදියට ලැබිච්ච අයිතිවාසිකමක් තියෙනවා. ඒක විතරයි. පැහැදිලිද? ඒක ඉස්සෙල්ලාම බලන්න ඕනේ මේ පොසිෂන් එක whether it is related to his capacity shareholder. Director, promoter. If it is sorry, related to his capacity as shareholder, then why the contract for? Right? So by other provisions, no contract for, but it may be treated as implied terms of other contracts. So that is the concept we recognize here according to the provisions contained in the article. We can go to the part B. Rahim is a director of Picasso Limited, public company newly incorporated on 1st of March 2024. Prior to the incorporation of the company as the promoter of Picasso Limited, Rohan had engaged in several pre-incorporation contracts. Rahim is a director. He is a director of Picasso Limited Public Company newly incorporated on 1st of March 2024. Prior to incorporation of the company as the promoter Picasso, as the promoter of Picasso Limited, Rohan had engaged in several pre-incorporation contracts. Further, Rahim seeks your assistance to get clarification on following matters. So actually there are three persons. Rahim is a director, and the company name is Picasso, and the promoter Rohan. Promoter is the Rohan. So Rohan engaged in pre-incorporation contracts on behalf of the company. So Rahim seeks your assistance to get clarification on following matters. Legality of the pre-incorporation contracts under the Companies Act. Difference between executive director and shadow director. The duties of a director on serious loss of capital and insolvency of the company. What is the duty of the director? At the last part it says legal position of the secretary of the company. Right? Right. Actually, what is the legality of the pre-incorporation contracts? So when we consider the legality of the pre-incorporation contract, we have to consider two legal systems. One is under law of agency and under the Companies Act, Section 22. Right? According to the law of agency, it says the company cannot ratify its pre-incorporation contract. Right? So that is the concept recognizing the yes, case laws, right? According to the case laws. ඒක මතකද? pre-incorporation එක පොඩි ඒක හැදිලා ආපු විදිහක් තියෙනවා. ඒ උඩින් කියන්නේ. ඒක කොට ආය ආගන්න. ඒකේ ඔයගොල්ලෝ කරලා නැහැ ඔයගොල්ලෝ EXP override කරලා override කරලා ඒක ආවෝ ඒකට හේතුවක් තියෙනවා. ඒ වගේම දැන් ඔකේ කෙල්ල versus Baxter කියන කේස් එකේ තමයි මොකක්ද කියන්නේ company cannot ratify its pre-incorporation contract. your, Galle versus Lanka. Right? This is the case. This will be whatever ratification. Right? Ratification means approval. Very simple, right? Now suppose A, right? A, B, there are two persons, right? A did not appoint B as his agent. No authority given to B. Right? But what happened, even though B has no authority, he engaged into contract with C on behalf of A. Right? He engaged into contract with C, suppose 1st of January, he engaged into contract with C without having authority. Malayak network, C in the resort at Lampira, A will. Malayak man, trust. Then actually, contract between the B engaged into contract with C or first of January. Right? Thereafter, after B engaged into contract with C, A has given the approval for the contract. Suppose the approval is given on 5th of January. Approval. After the contract was made, right, by B on behalf of A has given his approval. So that approval is known as ratification. Approval is ratification. Once the approval is given for the contract, right? Once the approval is given, then what happens? Agency created between A and B. Agency created. Once it is approved by this party, agency created between A and B. Effectively, we can name them after agency creation of the agency, we can name these two parties as, right, principal and agent. These the agency created. Right? So this is known as creation of agency by ratification or subsequent approval. Agency created. Right? Agency created between A and B. Agency created means binding contract formed between these two. Contract form. Right? A will be bound by the contract with C. Binding contract. Then we can identify these three parties, right? After agency is created, A is the principal, B is the agent, and C is the third party. So this will happen under the ratification. He engaged into contract without having authority. Right? Then thereafter, this contract is approved by the other party, A. Right? Then what happened? Between A and B, agency created. It is known as creation of agency by ratification. Subsequent approval. Agency created between A and B, it means binding contract formed between, right, A and C. Or in other words, actually we can say A will be bound by the contract with C. Right? Contract formed between A and C. Now the issue is from which date binding contract formed. Right? From the dates on which B engaged into contract with C, or on the date that the contract was approved by A. On which date binding contract from here, 1st of January or 5th of January. Binding contract form 5th of January, first year. Because here ratification has retrospective effect. Retrospective effect. It means, right, the contract is approved by A on 5th of January. Once it is approved on 5th of January, then binding contract form between A and C from the beginning, from the day on which we engage into contract with C. Understood? So this is the appeal legal here, appeal retrospective. And ikai paha अनुबंध करना इकाई एक ऐसी करगत gives इकाई एक ऐसी करगत gives में इकाई paha अनुबंध करना अनुबंध करना वहाँ होगा इकाई एक इकाई एक ऐसी करगत gives में इकाई paha अनुबंध करना वहाँ होगा और ये इधर क्यों भाई ए सहसी अगर दिविसु में कहते हैं ना दिविसु में ऐसे लेते हैं पूरा ही का लेकिन इका ये एक का from the beginning binding contract form between A and C from here and अपील देने वाला वे अनुमति दे देगा इका एक बाहर नाम दिविसु में कहते हैं इका ये एक का वास्तव में अपील देने वाला retrospective अपील देने वाला ने सामान्य नीति प्रणाली बैकग्राउंड कथा है व्यापार अबे सिविली की आगे बोलोगे विशेष अवस्था ये जरूरी there is a binding contract form between A and C from first of January. It's a contract form between A and C from first of January. Right? From the beginning. Now what happened? The company is not incorporated. Pre-incorporation. Now here what happened? So make a mode what a suppose B engage into contract with C on behalf of future company. The company is not incorporated, right? So B engage into contract with C on behalf of the future company. Right? Then what happened? That is 1st of January. Then thereafter, on 3rd of January, the company is incorporated. We engage in the contract with C on behalf of the future company. Right? On 1st of January, it is 1st of January. Then after that, company is incorporated. A is the company, company is incorporated on 3rd of January. Then thereafter, right? On 5th of January, same as here, on 5th of January, company ratify the contract. Ratify the contract. That is ratification, date of ratification. Now what happened? Once it is ratified, it is affected to the past. Then from the beginning, binding contract form between principal and the third party. Right? So from 1st of January, right? From 1st of January, like this. From 1st of January, 1st of January, from which day? From the beginning, right? From 1st of January, a binding contract form between principal and the third party. But here, the company was incorporated on 3rd of January. On 1st of January, the company is not in existence with contractual capacity. On 1st of January, the company is not available, not in existence, not available on 1st of January. On 1st of January. Right? It is ratified. Promoter engaged into B engaged into contract with C on 1st of January. Then thereafter company is incorporated. After incorporation, company ratifies the contract. Once it is ratified, it is effective to the past because retrospective effect. Ratification has retrospective effect. From this date, binding contract formed between company and the third party. But only thing is, on this date, the company is not in existence with the contractual capacity. Like how company can engage in contract from here. Right? Because the company was available on this date in order to create binding contract. Yes. එදාය ඉපදිලත් නැත්නම් ආරම්භයකට එදා ඉන්න කොහොමද වල්කිනුනේ and එදාය ඉන්නෝඩ් ඉතියම නා gives you anything ඕක තමයි සංකාර. Therefore in this case, Galle versus Baxter case, right? For L, the company cannot ratify its pre-incorporation contract. So this is a pre-incorporation contract. Now, B engaged into contract with C, right? On behalf of the future company. Therefore, on this day, the company is not yet incorporated. Pre-incorporation contract. Therefore, even after the company is incorporated, that company cannot ratify it. This ratification is invalid. Therefore, no agency created between, right? No agency created between company and the person who engaged into contract on behalf of the company. No agency created. Right? Therefore, what happened? No binding contract formed between these two parties because of pre-incorporation contract. Then actually who is responsible? B. He personally responsible to C, not the company. Right? Personally, the parties who engage into the contract, right, they are responsible, not the company. Right? So even though the company ratifies the contract after its incorporation, no agency created by ratification. Right? Because of that reason, in the Galle versus Baxter case, for held that the company cannot ratify its pre-incorporation. සමාගම බිහිවෙන්නේ එකයි තුන. BC එක කිවිසුමට ඇතුළත් වෙනවා සමාගම වෙන්නේ එකයි එකයි එක වෙනකොට සමාගමක් නැහැ. ඊට මේ විදිහේ සමාගමක් නැහැ. පෞද්ගලික එකක්. That not in existence. Right? එතකොට පස්සේ බිහි වෙලා incorporate වෙලා මේක ratify කරපු ගමන් අර අපි කියවනේ retrospective effect එකක් වෙනවා. ඒ කියන්නේ binding contract එක. ඒ කියන්නේ සමාගමයි කුපිරි පාර්ශ්වය අතර පිරිසුමක් වෙන්නේ එදා. එදා ඉඳන් සමාගම වාක්‍යයකට බැලුවා පිරිසු. හැබැයි එදා ඉඳන් වාක්‍යයකට බැලෙන්න බෑ. එයා ඉතිරිලා incorporate වෙලා නැහැ. එදා නෑ සමාගම. නැති එකක් කොහොමද එදා ඉඳන් වාක්‍යයකට බැලෙන්නේ? ආණ්ඩුවේ ප්‍රශ්න තමයි ආවේ. ඒ නිසා මේ ගොඩේ විලා කියනවා the company cannot ratify its pre-incorporation contract. ඕක තමයි ආපු සිද්ධාව. But what happened on the Companies Act? Companies Act says, right? Pre-incorporation contracts may be ratified. ये वचन यहाँ रहता है. According to section 23 of the Companies Act, it says may be ratified. After ratification, it is valid. After ratification, valid and enforced. As the company was the party to the contract at the time promoter engaged into the contract. So same as like that, that contract is valid and enforceable. Now actually here the company is not available, but with the loan receives, the company was a party to the contract at the time they engage into the contract. So likewise, it is valid and enforcement. Right? Valid and enforcement. May be ratified after ratification, valid and enforcement. Right? Pre-incorporation. But here it says may. The word is very important. May, not shall. Right? May be ratified. It means that after incorporation, the company can ratify, either ratify or refuse to ratify. It is up to the company. May be ratified, not shall. Shall is compulsory. Compulsory to be ratified. Here it says may be ratified. So now what happened? Because of this wording, actually there's a uncertainty. We don't know the form. When we consider the from the point of view of the third party is not sure whether the company is incorporated. Right? So this pre-incorporation, whether the company will incorporate. So after incorporation, whether the company will ratify the contract, it is not sure. Therefore, what happened? Further, another provision related to the section 23, section 23 subsection 2 says, when a promoter engages to contract with third party on behalf of the future company, he will give two warranties. Two warranties. He will give two warranties to the third party. So here, he will give two warranties to C. Right? What are the warranties? The first one is the company will incorporate. Right? Will incorporate within reasonable time. Reasonable future time. Right? Incorporation. First warranty is with regard to incorporation. And the second warranty is after incorporation, the company will ratify. That is regarding the ratification. Company will ratify the contract. So what happened? So because of these warranties, if the company is not incorporated in the future, right? Then actually promoter has violated the warranties. Therefore, third party is entitled to regard everything. Even though the company has incorporated, refused to ratify the contract, then second warranty is breached by the promoter. The third party can regard everything from the. So by that way, companies have recognized the pre-incorporation contract. Therefore, actually, according to the provisions contained in the Companies Act, pre-incorporation contracts may be ratified. Here, according to the case law, it says, right, the company cannot ratify its pre-incorporation contract because of that reason, not in existence of the state. Right? Cannot be ratified. But here it says may be ratified. Right? So there is the difference between common law and the statutory provisions contained in the Companies Act. And in the evidence, so this is the common law, and this is the statutory Companies Act. Provisions contained in the Companies Act. Right? With regard to pre-incorporation contract. when we consider section 23, is specifically mentioned, notwithstanding anything to the contrary in any law. Therefore, we take Patayo, Ubak, Sana, Una, Sierra Patanga. Here are common law, Munoa, you are free incorporation contract, may be right? After ratification, the legal process, but which promote engaging into free incorporation contract, it will give two moralities to the third part. First one is with regard to incorporation, second one with regard to part of the character. Our media of that, we are still a meaning. Someone part. Legality of the pre-incorporation contract under the company secretary for EXP. Everybody has one product, Malaya market, we can payroll and an agency, an agency, an agency may be created. An agency may be created between two parties by ratification. Then next slide we can say ratification means principal has given his approval for the contract which is made by the agent with the third party without having authority. So no authority, right? That's why the principal has to give the approval without having authority. Right? Next slide we can see. Next slide. The ratification has retrospective effect. The ratification has retrospective effect. As retrospective effect. Next time we can say it means when the principal ratifies the contract, when the principal ratifies the contract, a binding contract formed between principal and third party, formed between principal and third party from the beginning. From the beginning. It is related to the past, right? From the beginning. Binding contract formed between principal and third party from the beginning. So beginning කියලා අපිට කියන්නේ මොකද්ද? That is the date. අපි උඩ සමානව විලා that is the date on which right agent engaged into the contract with third party. Engaged into the contract with third party. So 1st of January, agent engaged into contract with third party. So from that day, binding contract formed, right, between principal and third party. Right? Next time we can say, right? Therefore, on the date agent engaged into contract with third party on the date the agent engaged into contract with third party the principal shall be in existence with contractual capacity. Shall be in existence. The principal shall be in existence with contractual capacity. ඒ කියන්නේ මේ දවසේ එයා ඉන්න ඕනේ. විසුම් ඇත්තක් වෙන්න පුළුවන් හැකියාවෙන් යුක්තව එයා පවතින්න ඕනේ. Shall be in existence with contractual capacity. Right? Then next time we can say therefore in Galle versus Baxter case, court held that the company cannot ratify its pre-incorporation contract. Pre-incorporation contract. Cannot ratify its pre-incorporation contract. this date, the company is not in existence. Right? Next slide, we can see however, right? Next slide, however, according to the according to section 23 of the Companies Act, according to section 23 of the Companies Act, a pre-cooperation contract pre-cooperation contract pre-cooperation may be ratified. May be ratified. May be ratified. Next slide we can say after application, the contract is valid and enforceable. Valid and enforceable as valid and enforceable as the company had been a party to the contract. Had been a party to the contract. Had been a party to the contract. Had been party to the contract. On the date, on the date, promoter engaged into contract with third party. Promoter engaged into contract with third party. Promoter engaged into contract with third party. Like, however, with promoter engaged into a pre-cooperation contract he shall give 2 warranties to the third party. He shall give 2 warranties to the third party. That is number one, the company will be incorporated within reasonable time. The company will be incorporated within reasonable time. Number two, the company will be ratified the contract. Will be ratified the contract within reasonable time after its incorporation. After its incorporation. So that is the legality of this incorporation contract. Difference between executive director and shadow director. What is the difference? Now we categorize some directors like executive director, member of board of directors is a member of board of directors plus and officer of the company. Right? He has two positions. One is he is an employee of the company. At the same time, he is a member of the board of directors. Shadow director, he is not properly appointed to the board of directors. Then he advised the board of directors from outside. And the board of directors comply with the advice given by the shadow director. Right? That is a duty on the duties of a director on the serious loss of capital. And insolvency of the company. Insolvency, unable to settle. What is the meaning of serious loss of capital? What is the duty cast on a director? Serious loss of capital means, in simple meaning is, there is an accumulated loss in the company. That is the serious loss of capital means accumulated loss. Or actually the company tax says serious loss means net assets of the company. Right? Net assets of the company is less than half of the stated capital. Net assets. Then we have to consider the total assets and liabilities. Difference between total assets and liabilities, that is known as net assets. Net assets of the company is less than half of the stated capital. Stated capital we have to consider and half of that. That is known as serious loss of capital. That's right. Actually, this didn't happen because of accumulated loss in the company. Then what is the? It is not mentioned. It is not asked about the serious loss of capital. What is the duty cast on a director if there is a serious loss of capital? Yes, what is the duty? And the second one is insolvency. That is, the company unable to pay its debts in its ordinary course of business. That can be treated as insolvency, unable to settle the debts, right, in ordinary course of business. Then what is the duty? Cost of the delivery. Yes. If there is a serious loss of capital, then what is the duty? Or at EG, extraordinary general duty. Right? They also mother we are. Meeting කියලා කියලා තමයි ගොඩක් අය කියලා තියෙනවා. මොන මීටින් වලද කියලා. Extraordinary general meeting. Within 20 working days, he shall call EG, extraordinary general meeting. There are two types of meetings. Meetings we can divide into two: directors meeting and shareholders meeting. Shareholders meeting can be divided into two. We can further divided into two as AGM, annual general meeting, extraordinary general meeting, EGM. We can say shareholders meeting or general meetings, EA. General meeting means shareholders meeting, right? Instead of shareholders meeting, you can say general meeting. So, at AGM, EGM, they will pass resolution or decisions, right? They will take decisions. Right? So there are two types of decisions, or we can say resolutions. There are two types of resolutions, right? Ordinary, special. With our ordinary, special. Right? In an AGM, which type of resolutions can be passed? AGM, suppose AGM 4. Which type of resolution can be passed? In an EGM, which type of resolution can be passed? In an AGM or EGM, right? Both of right? Both type of resolutions can be passed. It may be ordinary or special. Here also, in an EGM, company can pass ordinary or special. Special resolution. But only thing is, in an EGM, extraordinary general meeting, in order to pass a special resolution, right? So generally, in order to call an AGM, not less than 15 working days notice to be given. Then meeting to be called. At the meeting, they can pass ordinary or special resolution. EGM can be called by giving 10 working days notice or 5 working days notice. 10, it is applicable to public company. If it is a public company, right, not less than 10 working days notice, company can call an EGM. Private company, not less than 5 working days notice, company can call EGM. Right? However, in an EGM, generally it will take 5 working days notice to be given in public and private company. In an EGM, right, if the company is going to pass a special resolution, then what happens? Not less than 15 working days notice. Working days notice. Because the reason is, now when we consider the provisions contained in the Companies Act, it has defined the special resolution. Special resolution is defined as this is a resolution passed by majority of 75% of votes, right? After giving not less than 15 working days notice. Am I here? Is a make it a plus. Not only these are right 15 working days notice to be given. However, further there is another provision, right? This requirements. That is, suppose the company unable to give not less than 15 working days notice. Immediately call the meeting. And the company wants to pass a resolution as a special resolution. How they can pass the resolution? Right? the company can propose and pass a resolution, right? By majority of so here generally 75% votes required, right? The company can propose and pass a resolution as a special resolution by majority of 85% of votes, right? Even if the company has given less than 15 working days, so if the company, right, has given less than 15 working days notice, then that resolution will be passed by 85% of votes. Generally 75, because not 15 working days notice is not given, it will be passed by 85% of votes. There is the provision mentioned in the Companies Act. Shall I mother the two kinds of shareholders meeting? We are not dividing directors meeting, directors meeting, shareholders meeting. Or with we can name it as meeting. AGM, EGM. Once in each calendar year, AGM to be held. EGM, all the meetings other than AGM is known as EGM because of emergency and unable to make country its AGM, EGM score. In an AGM, ordinary resolution or special resolution can be passed. EGM also, ordinary or special resolution can be passed. So EGM में special resolution pass करने का तो निकाल देंगे, तो देखा कितना वेट करूँगा, एक है डॉक्यूमेंट का विरोध करना, बुका खाली resolution क्या है योजना सामने क्या क्या स्थिर है, कामोरी का तो decision निकालना, तो एक का आवश्यक करा तो ordinary resolution निकाल तो pass है तो special resolution निकाल दीजिए कि ये भी काम how we can decide whether ordinary resolution or special resolution requires to take a particular decision. एक special resolution. वो क्या है उदाहरण एक तीन review in order to approve major transaction. Locate the name of the company, amend the ratio, right? Alter the articles, special resolutions required. Right? Even here, कोई नहीं किया, company secretary किया. In order to take this decision, special resolution required. By passing special resolution, shareholders can take this decision. Special in the companies. If it is not specifically mentioned, special resolution requires by passing ordinary resolution, any decision can be taken. Even समागम करते किया किया विशेष किया आवश्यक है इतनी तरह ये तो किया रहता कोई भी नहीं ordinary resolution नहीं pass करता you don't do a delay ordinary resolution नहीं ना so this is not specifically mentioned special resolution requires understood there is the link we have to consider about things अरे वहाँ पे ये हमारा पालन में किया दिया उदाहरण स्पेशल रेजोल्यूशन में आता है करता मैं आप पता करते हुए करता मैं वाइड अप दी कंपनी in order to wind up the company special resolution in order to reduce the stated capital reduction of stated capital special resolution right they are specifically mentioned in the company's act special resolution requires then we have to pass special resolution like this. If it is not mentioned specifically, by passing an ordinary resolution, any decision can be taken. That's all. Right? These are whatever we take a development or something. Ordinary resolution means that is resolution passed by simple majority of votes. Simple majority. Simple majority. Right? That is more than 50. More than 50% of votes, resolution can be passed. That is ordinary resolution. Like एक और मतलब है, right? EGM එකක් තමයි ඒකට call කරන්න ඕනේ. If there is a serious loss of capital. Right? Insolvency. Duties of the director of the serious loss of capital and insolvency of the company. Insolvency that means the company unable to make debts. We have mentioned under the lifting of bail of incorporation, insolvency of the company. What is the duty? Cast of the director. Call which type of meeting? Directors meeting. That is the duty. Right? Immediately, right? No time. Immediately, he must call directors meeting in order to decide to make an application to court for winding up or further carry out the business of the company. If he fails to do so, then as a result, the company continues business and liquidator is personally responsible to the creditors. Under the freedom of bail of incorporation, we have discussed. So there, the directors must yes, directors must call. The duty cast of the director all directors. Right? If there is a insolvency, right? If there is a serious loss of capital, director must call EG, shareholder, extraordinary general meeting. Right? Extraordinary general meeting. Okay, those are the duties of the directors. On serious loss of capital and insolvency. Legal position of the secretary. Legal position. Legal qualification, legal position. Qualification, if the turnover is more than 1 million, stated capital is 500,000 or more, qualified person to be appointed. Qualification measure, attorney at law, chartered qualified person, SIMA qualified person, can be acted as the secretary of the company. Now here it asks legal question. What is the legal question of the secretary? There are two cases. In first case, it says the secretary of the company is near an employee. First case. Right? But the second case, it says the secretary of the company is the chief administrative officer. Right? Therefore, secretary has apparent authority. Secretary has apparent authority to engage into transactions which are purely administrative. Only part of the Sambandhya the apparent authority. Right? Here the employee, he could take company secretary notes. Third party team. There are three parties to be company, secretary, and third party. On behalf of the company, secretary engaging to contracting third party. On behalf of the company. Therefore, actually, we can identify secretary is acting as an agent of the company. Agent of the company. This company is the principal. Right? Agent and principal relationship creates between principal and agent. Sorry, company and secretary. Agent and principal relationship creates right between secretary and company. Right? And the third party we can identify. Now let me consider the authority of an agent. Authority is power. Power of the agent. We can identify authority under three categories. First one is express, imply, and apparent. Three types of authorities: express, imply, apparent. Right? These two, we go to government actual authority. Actual. Right? Actual authority and apparent authority 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 can be divided into two: actual authority, apparent authority. Actual authority we can further classify as express and imply. So ultimately, there are three types of authorities we can. Now, in the first case, it says secretary, right, is here and employed. He can do what he is told to do. Right? It means the secretary of the company has only actual authority, or we can say express and implied authority. Only express and implied authority. Express authority means authority given to the agent in writing or oral. In writing or oral. Right? That is known as express authority. Right? කිව්ව වාචික ලිඛිතව දීපු බලය අනුව යාට කටයුතු කරන්න. ඒව නැත්තම් සමහර දේවල් ගැන හිතා ගන්න පුළුවන් මට මේ දේ කරන්න බලයක් තියෙනවා. ඒක තමයි ඉම්ප්ලයි. ඒක කියන්නේ ඉම්ප්ලයි authority. On that implied authority, he can engage in contracting. Right? So here actually, in first case, right, court held secretary is peer and employee of the company. Therefore, secretary has only actual authority. Actual authority. That is, he can do what he is told to do. Right? Or in other words, he has no apparent authority. No apparent authority. No apparent authority. He has no this type of authority. Right? That's why he named him as peer and employee. He can do what he is told to do. Right? He has no apparent authority. Now, when we consider the apparent authority, right, of the third party, apparent authority, now I told you on behalf of the company, secretary engaging to contract with third party. Right? Now, suppose secretary has no express authority or implied authority. No express or implied authority, no actual authority. Or we can say actual, without having actual authority, agent, sorry, secretary engaging to contract with third party. Right? Third party. Then what happened? Right? Because of this, right, the third set, recognizing the first case, he has only actual authority. Then the agent has, the secretary has no actual authority. Then what happened? The company will not be bound by the contracting third party. Without having actual authority, if the secretary engages to contract with third party, then the company will not be bound by the contract with third party. Now, in simple terms, actually, company is not responsible for the transactions made between secretary and the third party, because secretary has no actual authority. Right? Actual authority. But the second case, it says he has apparent authority, right? Without purely administrative nature. Apparent authority. Apparent can pay or give. Pay or appear. It appears to whom? Actually, the secretary has no actual authority here. No actual authority. But third party, it appears to third party that the secretary can engage into this transaction. And without no actual authority, actually the secretary has no actual authority, no express or implied authority. Even though no express or implied authority, it appears to third party, it appears to third, reasonably, it appears to third party that the secretary can engage into this transaction. So we have to consider the apparent authority from the point of view of the third party. Third party. Apparent authority means it appears to, reasonably, it appears to third party that the secretary can engage into this transaction. Right? Now here it says he has apparent authority with regard to administrative nature transactions. Right? If the transaction is related to administrative purposes, then the secretary has apparent authority. It means actually, even though the secretary has no actual authority, if we engage into contract with third party without purely administrative nature transaction, then what happens? Like third party can see, right? It appears to third party that the agent or the agent party, that the secretary can engage into this contract. Right? But actually he has no actual authority. But it appears to third party, this person can engage into this contract because this is the transaction is administrative nature transaction. Therefore, right, in the second case it says secretary is the chief administrative officer, therefore he has apparent authority without purely administrative nature. Right? Therefore, suppose the secretary without having actual authority engage into transaction with third party, then the transaction is related to administrative purpose. Right? Then, even though the secretary has no actual authority, binding contract form between principal and third party. In other words, we can say the company is responsible for that transaction because it is related to administrative purposes. Understood? So he has apparent authority. It appears to third party. Pay or give it. Apparent can pay. Part of the pay, who will pass? Who will pass the pay? They are Balak or Vedic Rana. Appears to third party. अब ऐसा तो मेरा Balak नहीं. जो who will pass the pay ना एक प्रमाण मापन लेकर who will pass करना वाले या तो एक यूज. और क्या है कि आप अपने लिए क्या करते हैं? और सीधा देखा देखना actual authority කියන කියන්නේ express හිතවාච වෙන හිතාගන්න. ඒක actual authority එකක් විදිහට තමයි සලකන්නේ. ඒක කියන්නේ ඒක පැහැදිලි express authority is given to the agent implied to know implied authority එක imply කරන්නේ කවුද? හිතාගන්නේ කවුද? Not third party. और second ये कभी agent කියලා නම් agent. ඒක හරියට මෙහෙම. හිතන්න බෑ. කවුරුහරි කෙනෙක් මට ලියුමක් දෙනවා. ලියුමක් දීලා කියනවා මෙන්න මේ ඇඩ්‍රස් එකට මේක තකන්න කරන්න. ඒකවල අපි ඒක වාචිකව දුන්නේ කියන orally, right? I am given the authority to post the letter to the given address. Right? Orally that authority is given to me. But in order to perform this activity, I may have to imply some other activities which are related to this main activity. And what is it here? I better way address it. Particle, but it. Have a meaning correct. Our deal correct and not it. You can have the Sarla head, Ardu Sarla. You can then you put a Pankara Kila Mata Guna, there I keep the particle. Have I go with Karatana, you can take Karatana, you cover at Salina Garden. Uttara Garden. And the Prahamika, Sampal Garden. Right? So these are the related activities to the main business. Right? Therefore, even though that related, in order to perform that related activities, no actual authority, no express authority, no express authority is given to the agent. But agent can imply that he can purchase what he can purchase stamps. Because they are related activities to the main business. Understood? You know, right. What are the keyword? Karana, we are animated to Karana. Have a related, incident, or related activity. Here, Karana, he called it a actual activity. And apparently, I mean, after a matter, Balayat, no, to the part of the he has no apparent, sorry, actual authority. That is not an apparent authority. And the second, the position again, apart from not the captain. They finally in a kind of Myanmar, say the thing. Here, an employee, he has only actual authority. Therefore, he can do what he is told to do. Right? He has no apparent authority. We are not particular, Saman, second Canadian express implied authority, particular Saman, to give Basha or the apparent authority to mother, Saman, to give Basha, that Balkan village, I mean, Asutari, right? Secretary is the chief administrative officer of the company. Therefore, he has apparent authority, right, to engage in contract with third party on behalf of the company, which are purely administrative. Paripalan Pakitura, Bedu, Eva Karanda, and they are the apparent authority of the even though the secretary has no actual authority, if it is reasonably appears to third party that he can engage into this transaction because the transaction is administrative purpose transaction, then what happens? Even though the secretary has no actual authority, the company is responsible to the binding contract for which it company is. It is not apparent authority. Have I limited or not? परिपालन का संपादन भी था ये वाला मतलब क्या है अपराध अथॉरिटी का नियम साधारण पूरी बात तीनों मीटिंग करना मुझे पता है उदाहरण के लिए या का तो पास में आ गई नागरी पैनोरामा पीडीएस की नागरी लेकिन पास में सेकेंडरी या का दिक्कत वार्षिक व्याप्त बालया कहते हैं यार अध्यक्ष को लोग दबाव विमान वाहन है खाए है ना ये सवाल कर रही है सेकेंडरी ये वाहन है खाए ना बोर्ड रिवर्स का टाइम कभी भी आप नहीं अरे यार तो लिखित बातचीत तो ये बालया कितनी है ये कितनी तो उधर प्रश्न का समाधान ना आयर terus warna ayat terus lewat bagi pertanyaan saling lewat orang apa tuh bagi orang itu mana ada jam kan sekitar kilo putih itu lewat mana muda tidak ada pas itu dia ada kawan ini dia bilang chief administrative officer he has apparent authority without only administrative means hiring vehicle is administrative for the administrative purpose therefore it is administrative transaction therefore he has apparent authority, therefore the company is responsible to pay money to the vehicles hired by the company, hired by the second. And the Indian can be included. I think later, Pipal, Tapi Dua, and the country is something I think. Aliamino, Alipa should be it is a hiccup someone to work here. The question is not weeks, apart from the अभी तक क्या है एक्चुअल प्रोडक्ट की तरह ही अभी कांटेक्ट कर रहा है ये वाले बस को देखे तो और पोगीला आते हैं ना और बड़ा इंदा से आते हैं ठीक है मैं तो देख के हम पर तो देख देखिए ना वाइंडिंग कप तो लिखना लगता है मैं आगे में कप ला रहे in the process of winding up a company the process of winding up a company by court refers to the winding up by court the court appoints අර අපේ summary එක ලස්සනට තියෙන එක මතක තියාගන්න පුළුවන් summary එකක් තියෙනවා ඒක බලන්න ඒක මතක තියාගන්න පුළුවන් proceeding on the winding up එකේ winding up වල proceeding හරිම සරලයි අර steps හතරයි පහයි තියෙන්නේ ඉස්සෙල්ලා මොකද කරන්නේ an application to court by way of petition then what happens once the application is made to the court official receiver is appointed official receiver is an officer of the court right appointed by the court in order to monitor the affairs of the company until the winding up order is given official क्या अभी क्या है तो receiver का काम करने के बाद में official receiver dealer බාර ගැනුම් කරනවා يعني සමාගමක් විශ්වාස හරින්න කියලා ඉල්ලීමක් කළාට පස්සේ ඊට පස්සේ දැන් සමාගම විශ්වාස හරින්න නෑනේ එතකොට අධ්‍යක්ෂකවරුන්ට මේක කරගෙන යන්න දුන්නොත් තමයි ලෙඩක් වෙනවා හරි ඒගොල්ලෝ අපි මේක ලේඅවුට් කරන්න පුළුවන් සංඛ්‍යාව ඒ නිසා මොකද කරන්නේ අධ්‍යක්ෂකවරුන්ගේ බලය අයින් කරලා මේක මොනිටර් කරන්න अधिकरणे निलधारित पत्र अधिकरण निलधार यार तमें आपने हंधुना ऑफिशियल रिसीवर राइट ही इज एन ऑफिसर ऑफ द कोर्ट මෙයා මොකද කරන්නේ මෙයා කියන්නේ ऑफिशियल रिसीवर अपॉइंट කරාට පස්සේ හරි එයාම తాවකාලික බේරුම් කරුවෙක් විදිහට පාත් කරනවා ප්‍රොවිෂනල් ලික්විඩිටි ඒ කියන්නේ මේ දුරේ නාම වෙනවා by virtue of his office official receiver be appointed as the provisional liquidator. Right? Provisional liquidator is right, he acting as the liquidator until the winding up order is given. That is for a short period of time. He appointed as the provisional liquidator. That තාවකාලික බේරුම් කර. Sorry, ඈවර කර. බේරුම් කරන්නේ. ඈවර කරුවෙක් එයාපත් කරනවා. එයාම තමයි हर by virtue of his office क्या ठीक है ये दूरे वास्तव में क्या कर लेते हैं यार जनाब तो क्यों ना हम यहाँ सेना पत्ती वाले कमांडर है ना थ्री फोर्सेस का आर्मी वाले हम का व्यवस्था आर्मी वाले जैसा मित्र इधर official receiver by virtue of his office be appointed as the provisional liquidator තාවකාලික ඈවර කරුවෙක් එයාපත් ඊට පස්සේ මොකද වෙන්නේ affairs company के affairs के मेंबर मॉनिटर කරගෙන යනවා ඊට පස්සේ winding up order එක දෙනවා basic ඒක තමයි තුන් විදිය ඉස්සලාම make an application to court right official receiver appointed by virtue of his office official receiver be appointed as the provisional liquidator right then winding up order is given तीन देगा विश्वास है then court will appoint liquidator until the liquidator appointed ඈවර කරු ඈවර කරු පත් කරනවා ඈවර කරු මොකද කරන්නේ he will conduct the liquidating process දැන් සමාගමක් ඈවර කරනවා කියන්නේ හරි සරලයි ඒ කියන්නේ ප්‍රවේශ ගත්තාම සරලයි මොනවා තියෙන වක්කම් ටික ඔක්කොම එකව කරගන්න ඒවා විකුණන මුදල් වලට පත් කර ගන්නවා. ඊට පස්සේ මොකද කරන්නේ? ණයනියක් ගෙවනවා. ඉවල ඉවර කරනවා. ඊට පස්සේ වයිටින් අප් කරනකොට මොනවාරි එක්ස්පෙන්සස් තියෙනවා ඒවල් ගෙවනවා. ඉතුරු වෙනවා නම් මුදල මොකද කරන්නේ? කොටස් සිංහලට බෙදලා දෙනවා. එච්චරයි වයිටින් අප් කරලා තියෙන්නේ. Collect the assets of the company, realize them, and out of that proceed settle the creditors, and after paying the winding up expenses, if any amount remain in the company, distributed among the shareholders. Ini pasti kan, bukan sama ya kan, kalau itu liquidity, right? Kalau ini kita only itu, right? In the process of winding up the company by court, the court appoint an official receiver. Literally, official receiver. Right? The first one, official receiver. He is an officer attached to the court, who by virtue of his office may be appointed as the provisional liquidator. That's argument basic. Number two, provisional liquidator. Yeah, do they තාවකාලිකව පත් වෙනවා liquidator වෙනවා. තාවකාලික. ඇයවල කරුණේ පත් වෙනවා. Then until the කාලේ කොතේ තියෙන්නේ until කොයි දක්වාද? Until the winding up order is given by the court. Winding up order is the number 3 winding up order. ඊට පස්සේ එවන winding up order එක දෙනවා. ඊට පස්සේ තමයි liquidator appointed. Right? Therefore, he is an individual appointed to monitor the company for a short period in a manner that will ensure payback to the creditors. After the winding up order, the court may appoint a liquidator to conduct the winding up process. The commencement date of the winding up by the court is the date of petition. Date of petition. ඉදා ඒක තමයි පෙත්සම ඉදිරිපත් කරපු දවසේ නම් තමයි ඒක බලාපොරොත්තු වෙන්නේ. Effective date of the winding up order is the date of filing of the petition. Filing of the petition. Date of the petition. Number 4, petition. After the commencement of winding up, any sale, disposition, transfer of any property, is to be treated as void. Colombo. The winding up petition එක දාපු දවසේ ඉඳන් order එක දෙනකන් මේ අතරතුර කාලෙදී පිටුදිය sale මොකක් හරි විකුණන disposition බහැරට විකුණන්න ඉල වෙලෙකට බාර දෙනවා. Transfer of any property, right? Power එක දීපල power එක ඒ ඔක්කොම මොකද ශූන්‍ය void. ඒක බල රහිතයි කියන තමයි කියන්නේ. ඉතින් ඇප්ලිකේෂන් එකක් දැම්මම පස්සේ ගම්බීර කරන්න බෑ. ඒක ඔක්කොම බෑ. එහෙම යනවා දැන් උදාහරණයකට පාර්ටිෂන් නඩුවක් දැම්මම පස්සේ ඔකේ තියෙනවා ලිස්ට් පෙන්ඩන්ට් කියලා එකක් රෙජිස්ටර් කරනවා. ඉතින් ඒ ලිස්ට් පෙන්ඩන්ට් රෙජිස්ටර් කරාට පස්සේ ඇතිවෙන සියලුම පැවරුම් ආවම ඒක එකක්වත් බලන්න. ඒක බලන්න. මොකද නැත්තම් පිසු ගම්බීර කරනවා මේක කරගෙන යන්න බෑ. ඒක ලිස්ට් පෙන්ඩන්ට් එකේ තියෙන වැලිඩිටි එක ඒක. After ලිස්ට් පෙන්ඩන්ට් is registered, all the transactions thereafter to be treated as caveat කියන්නේ ඒක නෙවෙයි. caveat එකක් කියන්නේ දැන් අපි ඉදවට වෙන කවුරු හරි කෙනෙක් දුවතර ලොකුවක් කියලා රෙජිස්ටර් කළොත් රෙජිස්ටර් කරලා ආවට පස්සේ එයා අපිට මේ දවස් 14ක් ඇතුළතදී රෙජිස්ටර් කරන්න ලැබෙන දවස් 14ක් ඇතුළතදී caveat එක දාපු එකට ඉම්පෝට් කරනවා. ඉන් රයිට්. ඉතින් මේ එකක් ඇවිල්ලා කියනවා මේක ලියාපදිංචි කරන්න. මම මොකද කරන්නේ? දැන් ඒක මම ලියපු එක නෙවෙයි නේද? මම ගිහලා ටක්කල් උසාවියේ නඩුවක් දානවා. Within 3 months. I have to launch file an action in the court of law. We don't get the that deed cancelled. We don't get it cancelled. We have to file an action. So ඒක මට දැනුවත් කරන එක විතරයි කරන්නේ. ඒක අවලංගු වෙන්නේ නේ. caveat එක දැන් මම caveat එක දාලා කියනවා. ඊට පස්සේ හිතන්න මම වික්ක කියලා. මට notice එකක් එනවා. මම විශ්යයට මම ප්‍රශ්න කරනවා. දැන් ලියපු එක වැලි. ඒක උත්තර. රිස්පෙක්ට් නේ එහෙම නෙමෙයි. රෙජිස්ටර් කරාට පස්සේ අනිත් ඔක්කොම අවලංගු වෙනවා. රිස්පෙක්ට් එකෙන් පස්සේ කියන දවසේ ඔක්කොම අවලංගු. ඒක ඒතර තියෙන විශේෂය. ඊගෙත් එකේ නිකන් notice එකක් විතරයි. අවලංගු වෙන්නේ ඊගෙත් එකෙන් පස්සේ ගන්න අවලංගු වෙන්නේ. මෙතන ඒක අර ඊගේ ෆයිල් කරද්දම එකකින් පස්සේ සිද්ධ වෙන මේ ඔක්කොම ගන්න ඕන. ඊට බැලුවා. ඊට පස්සේ බලනවා. However, in the voluntary white visa, you can refer to the voluntary white visa, right? Shall appoint one or more liquidators to wind up the company voluntarily. Who shall appoint? For voluntary white visa. Shareholder. Here it should be shareholder. Compulsory white visa, court will appoint the liquidators. Voluntary white visa, that is right up to the shareholders. Shareholders will appoint the liquidators. Right. Then there are two modes of voluntary white visa. When the declaration of is made, then it becomes declaration of solvency. This is a declaration given by the directors, majority of directors, stating that they have inquired into all the transactions of the company and the company able to settle all the debts, right, within 12 months from the commencement date of the binding. So this declaration is given, then it is known as declaration of solvency. Then it becomes what? It becomes the solvency can happen. Solvency is settled, able to settle the debts. You can nine water pulua, samano. They can apply simply rubunda. Bakolot rubunda. Insolvency can unable to settle. Right? Establish mother solvency. Settle, able to settle. Insolvency means unable to settle the debts. Right? So in this declaration of solvency is made, then it becomes shareholders voluntary white paper. Unable to give, then what happens? If such is not made, then it becomes creditors voluntary white paper. Shareholders voluntary white paper, creditors voluntary white paper. There are two types of voluntary white paper. It depends on declaration of solvency. And after I give out the Puduan people, shareholders voluntary white paper. When I give out the bag people, they get bulk. Creditors voluntary white paper. White paper, by subject to supervision of the court, is where the company moves for a white paper. A petition may be made to the court by seeking an order that white paper shall continue subject to the supervision of the court. Subject to supervision moves for a
supervision of the court.
So, supervision of the court. Winding up by subject to supervision of the court is where the company moves for a voluntary winding up. Voluntary winding up එක යනතරදී ගිහිලා කවුරුහරි කෙනෙක් ප්‍රෙස්සමක් ඉදපත් කරනවා voluntary winding up එක අධිකරණයේ අධීක්ෂණයක් කරන්නේ. ඒකද කියන්නේ. හරිද? ඒක winding up by subject to supervision of the court is where the company moves for a voluntary winding up. Voluntary winding up. A petition be waived to the court by seeking an order that wildlife shall continue subject to the supervision of the state.